Foss versus the Arizona Board of Regents. Each side will have 20 minutes to present their argument. Appellate, you may reserve any amount of time you want for rebuttal, but you'll have to keep track of your own time. That's why we have a clock at the podium. We are recording the argument, both in audio and video, and I think we're like streaming the argument too. So when you come forward, please identify yourself and your client so that when we review the video, we can keep track of who is who. We've read the briefs and the record, and we've covered the case. We're familiar with the law and the facts. So when you begin your argument, just start off with what you would like for us to consider. Counsel, you may begin.
May it please the court, my name is Lance Entrican, and I am here today arguing on behalf of appellants Michaela Foss and her companion appellants in the putative class. We are here today, and for the record, I'd like to reserve the final 4 minutes of my time for rebuttal. We're here today talking about standing. That was the basis of the trial court's decision, was whether or not there is standing in this case, and the trial court determined that there was not. This is a case that was brought in a state court of general jurisdiction pursuant to the Arizona Declaratory Judgment Act. And we weren't just claiming the Arizona Declaratory Judgment Act. You need an actual cause of action, and we had one, and that we were also claiming.
So, counsel, you're saying that nothing beyond standing, that the 12b6 ruling wasn't premised upon the failure to establish the elements in your complaint, to allege sufficient elements or facts in your complaint to withstand 12b6?
Yes, Your Honor. My reading of the court's ruling was that she found there was a lack of standing. That said, if she determined under 12b6 that there were inadequately pled elements, the remedy, the appropriate remedy under Wigglesworth v. Malden and also under Duke v. Likens, which I cited in my briefs, is to give me an opportunity to amend, not to dismiss the case and upheld the dismissal on appeal. But I was never given an opportunity to amend. And I also filed a motion for reconsideration, and it didn't happen then either. But no, the court's ruling was pretty clear. She said that there was a lack of standing, and she was very clear as to why. She gave one reason as to why there was a lack of standing. We're in a state court of general jurisdiction suing under the Arizona Declaratory Judgment Act, and we're also asserting two causes of action.
But you want money, right?
That's correct.
Okay. So you're arguing then for kind of a sea change, where this kind of recovery might be available to anyone who feels that somebody else was unfairly advantaged at the hands of state government, right?
No, I would not agree it's a sea change. I wouldn't.
Well, how is your theory of recovery, leave all this DACA stuff to one side for a second, how is your theory of recovery any different than my saying citizen X underpaid their taxes, I want to pay a proportionally similar level of low taxes?
The difference is that in 8 U.S.C. 1623, it's very clear. It says, notwithstanding any other provision of law, an alien who is not lawfully present in the United States shall not be eligible on the basis of residence within a state or a political subdivision for any post-secondary education.
I know what the statute says. Nothing in there creates a right of recovery for any private citizen. So I'm wondering, if you think the Arizona Declaratory Judgment Act does that, why wouldn't every statute that imposes some sort of standard for financial liability or recompense give rise to a private cause of action for damages?
Because we are not claiming, and this is how our claim has been characterized by the trial court, we are not claiming a private right of action under 8 U.S.C. 1623. We never did. We are claiming that there was a breach of contract.
Okay, but that gets back then to my setting aside all this DACA stuff. I mean, I understand that that adds a certain sheen to the argument, but at its core, the claim is not based on a right to recover under the statute. The claim is based on Arizona state law, right?
That is exactly right.
Okay. And so I'm struggling to see why such a claim would not apply every time one person wrongly secures an advantage financially in connection with state government.
Well, the limiting factor...
Under a statute.
Yes. The limiting factor is this. They had a contract with the Arizona Board of Regents, effectively. They had a contract with them. In the Frank Cush case, the Rutledge case, Kevin Rutledge case, the court held that the relationship between the student and the university is contractual as a matter of law. In this case, we pleaded facts in our complaint establishing that the relationship was in fact contractual, not as a matter of law, but based on the facts. And since that complaint was never answered or rebutted, that is the record before this court. There was a contract between my client and the state. One element of that contract was illegal under federal law, the price they were charging. And this is not a new innovation. I just got a decision from this court 6 months ago in Ansley v. Banner, where our argument was our clients are third-party beneficiaries of a contract, and pursuant to that contract, they are being overcharged under federal law. This court had no problem finding standing. Ironically, Cameron is here today. He and I have been fighting this case for 8 years. Cameron is a superb advocate, as I'm sure this court is aware, and we've fought on a lot of issues. That particular issue we haven't fought on in years. This court has rendered 3 published opinions where it accepted that we had standing to assert the contract had been breached because one of the elements was a violation of federal law.
Well, I think
this is not creating a new area.
If the question is purely one of standing, you might argue that you have standing to seek a declaration that the practice of offering tuition out of compliance with the statute should end, but that doesn't translate to a cause of action for money.
Well,
that's where I'm falling short. I think I can much more easily see standing to seek a declaration, but you're seeking much more than a declaration.
Well, right now, yes. In the prayer for relief, we have requested that the monies improperly collected under federal law be refunded. But that in itself is not a basis for dismissing our complaint without a response even being filed solely on a standing theory that we do not have standing. I mean, that's getting into damages, which is somewhat down the road.
So counsel, you say standing, but I have the minute entry in front of me, and it says that you failed to state a claim because your claim is premised upon this statute. So let's take each of your three counts in turn. You have a declaratory judgment claim, is that right?
That is correct, Your Honor.
And would you concede that one of the elements or requirements of a declaratory judgment claim is a protectable interest in a a controversy that is recognized, justiciable controversy?
Well, I don't want to state that I would concede there's a case or controversy requirement because that's constitutional. I think the requirement is set forth in ARS 12-1832, which is any person interested under a written contract or other writings constituting a contract, or whose rights, status, or other legal relations are affected by a statute may have determined any question of construction or validity arising under the statute or contract.
So, counsel, I have several cases here, and I think you've actually cited to some of them. Arizona Society of Pathologists, Land Department, and they all say that on a motion to dismiss under the Declaratory Judgment Act, the plaintiff must allege sufficient facts to both a protectable interest in a justiciable controversy over denial of that interest. Are you now saying that these cases are wrong and you're asking us to change the law?
I'm not saying those cases are wrong, no. And I'm not asking you to change the law.
So is that the law?
What you just said about a protectable interest?
Okay, the Uniform Judgment Act, in order to state a claim under that act, do you have to allege a protectable interest and justiciable controversy over denial of that interest?
I would argue that yes, you do, but I again refer to the plain language of the Declaratory Judgment Act itself, which tells what you have to allege in order to receive a
So that's a
declaratory
yes.
judgment. Yes.
Okay, what is your protectable interest here?
They were charged a sum for their tuition that it was illegal for them to be charged under federal law. So they were each overcharged to the tune of $15,000 each. That is a protectable interest.
Well,
This
were
court
they,
just...
Were they overcharged, or were others undercharged?
They were overcharged.
Really?
Yes.
Well, why did they sign up? Why did they even show up to school?
Because they weren't familiar with 8 U.S.C. 1623 as I am.
Well, that doesn't suggest, though, that they were overcharged. I mean, 8 U.S.C. 1763 is just one source of a possible overcharge in your vernacular. Right? If some student from Vermont is mistakenly offered in-state tuition, say they forged their driver's license or something like that, but some American citizen from Vermont just happens to be paying less than they should, isn't that the same case?
No, I don't know that it is.
It
This
just
is...
really bugs you that these people were paid less than they should.
No, it doesn't really bug me. It's illegal. Under 8
But it's illegal under Arizona law. It's illegal to charge that student from Vermont in-state tuition too.
Right, how do you pick and choose which statutes are going to be grafted into this contract? If you have Arizona statutes, that would make it illegal to pursue your theory, and you have a federal statute that goes in the other direction. I mean, how do we pick and choose?
You don't
what's
have that
included?
problem because this court and the Supreme Court have both stated that Arizona law is consistent with 8 U.S.C. 1623, and it agrees that this practice was illegal. That was a decision just rendered by the Supreme Court last year.
Okay, so how does that statute give you a protectable interest? But we have to look at that statute, right? And that
Yes.
statute, I mean, I understand you pivot to the contract and it's all in the contract, but let's focus on that statute. And we don't need to worry about private right of action. We can look at that statute and show me where it protects, operative word, your client's right to receive a particular tuition rate.
In Ansley v. Banner Health, it states, they made this same argument, and this court 6 months ago said every Arizona contract incorporates federal law as it existed at the time of the contract as an enforceable term of the contract.
What is the
That was 6 months
protectable-
ago.
So show me in this statute where it says my client is entitled, protectable interest, to receive a certain amount, rather than the inverse, which is an instruction to an institutional university or board that they cannot provide in-state tuition unless it is provided. Where is the protectable interest, the grant, the entitlement?
Again, I would refer to Ansley v. Banner. And Ansley v. Banner, they were saying the same thing.
Yeah, but can we focus on the statute that's at issue in this case? Where in that statute is the language on which you rely?
The statute in this case does not say, and you shall recompense them after the fact if you illegally overcharge them. It does not say that.
Which is hardly surprising because I'm unaware of any statutory scheme that would do that. In fact, you've emphasized that the practice was illegal. That's fine. They need to charge these students more. But I'm unaware of any statutory scheme that allows the gotcha to say, we were overcharged. Your whole position is my clients were overcharged because they did what was legally required, which is pay the tuition that was legally required and receive the education in return that they were legally entitled to. But because the state did something illegal over here, suddenly my contract needs to be reformed. So the whole theory seems to rest on illegality, which is novel to me.
There are numerous cases decided by our state Supreme Court that say a contract incorporates federal laws that existed at the
You've
time.
made that point. So
And-
why don't you address my question? Let's talk about the logic of your argument.
The same argument was made in Ansley v. Banner, which was
Well-
just published by this court. They said the same thing. They said, hey,
You have
all...
any other cases besides Andy? Because I feel like we've tread that ground pretty well.
I do. Schwab v. State Farm, 558 P. 2nd, 942. They came to this court and said this contract violates the Financial Responsibility Act. That same argument applied. This court entered a ruling that the contract did not, in fact, violate the Financial Responsibility Act. There was no private right of action under the Financial Responsibility Act. That was
But
stipulated.
that's declaratory relief, right? You're saying this contract is invalid because of some illegality. And I think, as we've discussed, there's little question that if it were actually not already decided, your clients would have standing to challenge the legality of the practice. But you're well past that now. You've asserted illegality as a base assumption of the case, which I think is fair. And the Supreme Court made that pretty clear. So where does that leave us? What do you have standing to assert? A damage claim is completely different from a declaratory judgment.
I would say again, and by the way, that's not the only case. I've cited 11 cases to this court that say that. In every one of those 11 cases, there is nothing that says, and there's a private...
cases, it doesn't matter. The proposition is not controversial. The question is its application to the facts in your complaint.
And with regard to my complaint, I'm not here on a lost motion for summary judgment. They were never required to answer. And it wasn't on some damages theory that the trial court was saying, well, but I'm not sure about damages down the road. It was, you don't have standing to assert this claim. That was the court's holding. The court stated explicitly. The court said... Sorry, go ahead.
Before you sit down, again, going to this federal statute, where does it say your client, and I'm not saying it needs to say your client has a private right of action or your client has, I think you said, recompense. Where does it say your client gets this relief, has a protectable interest?
Let me just read it to you. They cannot charge that rate, quote, unless a citizen or national of the United States is eligible for such a benefit in no less an amount, duration, and scope, without regard to whether the citizen or national is such a resident.
But that pertains to that pertains to the person who may not legally be here. It doesn't relate to your clients.
Well, I would argue that it does, because they are citizens or nationals of the United States who were charged tuition in a different amount, duration, and scope. It refers to both the class of people, the benefit, and the condition precedent very explicitly. And
Well,
again...
So your ellipsis, if I could just read it, says, an alien, this is the statute, who is not lawfully present in the United States shall not be eligible on the basis of residence within a state. That you didn't say that part, right?
Right.
And then for any post-secondary, and then you have the unless part. Is that accurate?
I believe so.
Okay. Yet that is an entitlement, a protectable interest that you're seeking relief under. And my only question is, where does it say your client gets this amount?
And I would argue in what I just read. But in the Ansley case, all the statute at issue said was this payment is payment in full. That's all it said. There was nothing that said...
This says the government shall not provide in-state tuition to undocumented aliens, right?
Yes.
And then we have one step removed, unless and then pointing to this other group, I guess, your clients. But the statute in and of itself is a restriction on government conduct, is it not?
Correct.
And it's part of the federal immigration code.
No, it's it was the specific intention behind the statute was to rein in government benefits as they were applied to undocumented immigrants.
Was there any specific intent expressed to confer remedies on people who might feel aggrieved by non-compliance?
I would suggest the statute itself confers that benefit quite clearly.
It would be great if there were language in there.
No language in the Ansley case said that. It simply said payment in full, and they interpreted that as having the same effect that we're talking about here, conferring a benefit on access patients. I have 15 seconds left. I'm going to need to go ahead and, I guess, reserve the final 10 seconds of my time.
Thank you, counsel. Ms. O'Grady?
Good morning, Your Honors. Mary O'Grady representing the Board of Regents. This case, the Superior Court dismissed this case for failure to state a claim, not on standing grounds. Failure to state a claim for relief because they have no right to the relief that they're seeking in this case. Plaintiffs in this case are out-of-state students, and as required by state law, they were charged out-of-state tuition to attend Arizona's state universities. They paid their tuition required by state law, and they received the education from our state universities that they paid for.
But
Now,
as we sit here today, you would concede that the practice that Charles was complaining about was illegal.
the practice that led to their complaint was for the
We
period
now
of
know.
time, we now know because of the Arizona Supreme Court decision, it had to do with whether the DACA students who were residents of Arizona were prohibited, were lawfully present, whether they were lawfully present for the purposes of this statute. Our Supreme Court concluded they were not lawfully present, so they were not entitled to resident tuition. So an injunction was entered, and even before an injunction was entered, policies changed, and those students are no longer charged resident tuition because of this statute.
Would you concede that if that litigation hadn't happened, but these students wanted to raise the question, they would have standing to raise the question in a declaratory judgment context?
Your Honor, standing here today, I don't know that I would concede that, that they would have standing in that, but I don't know that it.
It's pretty low risk for you, given that the Supreme Court's already
Yeah.
decided the issue, but okay, don't concede, that's fine.
Yeah, but we know that the governor and the attorney directed the Attorney General to bring that lawsuit, and our Supreme Court has decided that issue.
But if they did have standing, would they be, what basis would there be to credit them back tuition?
None at all, Your Honor, none at all. And I think even in Judge Swan's question, he's talking about getting the same type of relief that the Attorney General sought, which was an injunction to stop the practice and bring them into compliance with 1623. There is nothing in 8 U.S.C. 1623 or anywhere else that gives plaintiffs, any out-of-state students, any claim for resident tuition. This is an immigration law intended to limit benefits to those who are not lawfully present in this country. And so it's a prohibition. It doesn't give out-of-state students any affirmative right to recovery.
You would concede, though, that going back in time for this 2017, 18, or 16, 17 academic
17.
year, in order for you or your client to be in compliance with federal law, given the DACA program, you would also have to provide in-state tuition to all U.S. citizens. Would you concede that?
Well, again, if you go back in time to that period, we know there was a legal question about how DACA students should be treated under 8 U.S.C. 1623. But I think what's important here.
Well, I'm not asking if there's a protectable interest and whether or not those students can say, look at that or somehow graft the federal statute into a contract. I'm just saying, to go back in time, to use Judge Swan's word, your practice was illegal unless you were to also provide in-state tuition to all U.S. citizens.
Your Honor, and that part of the court's holding and analysis in the Supreme Court decision in MCCD was, okay, now that we've decided that DACA students aren't lawfully present for this purpose of this federal law, now let's look at whether they're eligible. And as you note, under the federal law, the conditions that would permit the state to give someone who's not lawfully present resident tuition only if they essentially abolish resident tuition under the federal law, that unless these circumstances occur, this prohibition applies. It's not a rights-granting provision to the out-of-state students, but it establishes the circumstances under which you can
I understand. Can you address Ansley, which seems to be the centerpiece of your colleague's argument?
Yeah. Yes, Your Honor. In all of these cases, the focus has to be the federal law that you're analyzing. That was a case about the federal Medicaid statutes and how the payment requirements under the federal Medicaid statutes affected lien rights of hospitals. And so there's nothing in that case that informs how these particular laws ought to be analyzed.
But I think your colleague says that there's a sentence in Ansley that says the federal law at the time of the contract is incorporated. I guess, does it say that?
Well, and that's, in that case, what it talks about is the federal law that affects the rights of the parties. This is not, and there you had a federal law that was aimed at, setting up medical reimbursement, a system where people could get their medical services paid for. And so the plaintiffs there were sort of the core people protected by this federal law. Not so here. Plaintiffs are not the people who this federal law was about. And
right,
it talks
so
about...
that's the word, affected. So it says a valid statute is automatically part of any contract affected by it.
Yeah. And
was this contract affected in any way by that federal statute? Why or why not?
It was not, Your Honor, because this contract is governed by state, because the federal law gives them no rights, essentially.
Let's go back to state law. What state law creates the distinction between in-state and out-of-state tuition?
15-1802A, there it says that except as otherwise provided, a person having a domicile elsewhere than in this state is eligible for classification as an in-state student or no person having a domicile. So no out-of-state student is eligible for classification as an in-state student for tuition purposes. So there is a requirement in federal law.
That's really the issue right there, then, right? I mean, I feel almost as though the DACA ship was sailed. The Supreme Court has ruled. We know what's up there, but what we don't know is what the effect of that state law creating the distinction between in-state and out-of-state tuition is. We haven't really discussed that today. So I began the argument by asking about this hypothetical student from Vermont. Let's pick on someone from Nevada now. A Nevada resident decides that she wants to attend ASU. Presumably she's going to be charged out-of-state tuition under state law. And it's also possible that through inadvertence or some bad actor at the registrar's office, she might get a special break. And my question is, if that happens, and this Nevada resident is unlawfully afforded cheap tuition, what's the remedy?
Your Honor, they have no remedy. Their tuition, they're charged out-of-state tuition, they get out-of-state, they have to pay out-of-state tuition. If there's an error made on someone else's tuition, that doesn't affect anybody else's tuition. And that's true under state law, that's true under federal law, and I can't imagine a legal principle that would establish anything else.
But,
So-
but if that were going on, I'm going to ask you again, would you agree that another student might have standing to challenge the practice? All Nevada residents, for some reason, are getting really cheap tuition, and you have a New Mexico resident who'd like the same treatment. Could she sue?
Again, I don't
Purely declarative.
see how that injures
Well, on a
there. But
purely
if there's a broader
declaratory
question
basis,
about,
I can see how, I mean, the New Mexico student says, you know, if you were charging full freight to everybody who should be paying it, I would be enjoying nicer facilities in my laboratory and my gym. Okay, that, I mean, isn't that standing enough to pursue a declaration?
but at most, they would have standing to enjoin that violation as it relates to the Nevada people. There's no right to get any, because they have no right to resident tuition.
Okay,
The New
now
Mexico
an
people also
Arizona
don't have right to
student
resident.
says, wait a second here, I have a right to in-state tuition, but if all of these out-of-staters come in and consume my resources, I get a poorer education. Does an Arizona student have standing to seek a declaration?
Perhaps they do, but I think the point here is nobody has a right to, no out-of-state student has a right to resident tuition. And kind of narrowed to these facts, certainly 8 U.S.C. 1623, which is the core of their claims here, doesn't give any out-of-state student, plaintiffs or anybody else, a right to out-of-state student. All it does is lead to the Arizona versus MCCD holding, which if the state is improperly providing someone who's lawfully present resident tuition, then that gets enjoined. It doesn't give out-of-state students any right to pay resident tuition in violation of state law.
Has the state sought compensation for back tuition from any DACA students?
Not that I'm aware of, but going forward, everyone's assessed, resident tuition.
And if one were taxpayer standing or some similar doctrine to redress the practice that had been going on before, presumably one could seek a declaration saying the state needs to balance its books by getting some of that money back. I mean, that doesn't necessarily mean the money is paid to a student. But if one wanted to argue about the state's handling or the state's conduct in the wake of the injunction from the Supreme Court, one could do that in that context?
I hate to speculate on other types of litigation that might be filed, but subject to, subject to statute of limitations and all those restrictions. Who knows what sort of lawsuits people.
Would it be better if I said, for purposes of this argument only, a concession that will in no way be binding in the future? Would you help me out?
Subject to statute of limitations, and none of that opens the door to the kind of lawsuit that we have here, which is out-of-state students seeking to violate Arizona law and pay resident tuition. They don't get that right under federal law. There no additional questions?
Thank you, counsel. We
Thank-
appreciate your argument. And counsel, we'll go ahead and give you a full minute for rebuttal.
Just very briefly, with regard to a protectable interest in Stevens v. State Farm Mutual Automobile 519 P. 2nd 1157, someone filed a declaratory action in a state court, Superior Court of General Jurisdiction, to have a contract they'd entered into construed on the theory that the contract violated 28-1101, ARS-28-1101. This court upheld that construal and found that the contract did violate 28-1101.
What was 28-whatever?
The 28-1101 was talking about whether you can charge a particular sum to someone who's in the car with them during a car accident, whether you can make certain exclusions in an automobile liability policy.
Okay, so it was expressly regulating the animal we call an insurance contract.
Yes, but there was no suggestion from anyone that it created a protectable interest in someone who is a party to the contract.
Did it give rise to a monetary recovery by the plaintiffs in that case?
You know, Your Honor, I can't answer that question honestly because I don't recall.
That's kind of at the crux of this. I mean, the distinction between pure declaratory relief and monetary relief is why we're here. Can you think of a case in which monetary relief has been awarded in this context?
Actually, I was thinking about it as you were talking, and in Stevens, yes, I believe it did, because it said that the amount they were trying to charge under the contract was illegal, and it led to a refund from the insurer.
Thank you,
Thank you.
counsel. Your time is up. We appreciate counsel's arguments today. We'll take this matter under advisement and issue a decision in due course. We're going to stand at recess for the second argument, but we're going to stay on the bench and allow counsel to come forward. Thank you very much.